Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and I am so happy to be with you tonight. If you're ever in Minnesota and you run into a legal issue, or anywhere, I mean, whatever, right? If you ever run into a legal issue, you don't know where to turn, let me know. I can maybe help find someone. If I probably can't represent you unless you're anywhere near me. But if you're not, I might know someone who can. I might just have the connection to help you with your issue. And I am happy to make that connection if I can. I'm happy to do that. So we have tonight. We are broadcasting to multiple forms. Now, people expressed some concern last time that I was broadcasting to Twitch among other channels. And I did review the Twitch terms of service, and I saw nothing prohibiting the streaming of a channel or a show to multiple platforms in the Twitch terms of service. Now, maybe I cannot encourage people to use other platforms or something like that. And so, I certainly would not. I make this available so people can use a platform of their choice. And if you like Twitch, by all means, watch on Twitch. But with that said, Twitch, Stream Me, and YouTube tonight. Let me get the, whoa. I had my own thing there. Let me get the chat for Stream Me pulled up just in case. The chat for Stream Me seems to be glitching out. Like it'll start out on the restream chat here and show up in the window, and then it seems to just stop at some point. I think that might be a Stream Me issue. I don't know. I like the guys at Stream Me, but I'm not entirely sure their platform is performing where I would like it to. Oh, my document is off center. Let me get all this stuff set up. That would be great, right? if only I could have things ready to go. Okay, there we are. So that is nice. This is the the lawsuit filed by Anis Abdin. I am sure I'm butchering his name, and I apologize to him. He seems like a very nice gentleman. Anis Abdin is working on a video game. He's been working on it since 2014. He's been posting updates and blog posts and stuff like that with the art and the story and all of that stuff. He's been doing this, and then what happens? But he notices that Star Trek Discovery, a show that's from CBS Broadcasting and I think also airing on Netflix, that Star Trek Discovery is it has some very similar things involved, right? Some very similar concepts, very similar aesthetics, and so maybe, just maybe, there's something going on with that. I don't know. We're gonna take a look. I've not read through the lawsuit. I've read some media, some press about it, including Anis Abdin's blog posts about it most recently, just the other day, when the recent scheduling order came out. And maybe that's actually a good place to start. Let me pull up the scheduling order so that people understand where this case is before we're going to go back in time. Back in time or something. We're going to go backwards a little bit to the second amended complaint, and we're going to go through the documents. But before we do that, let's look at where the case is, because this just came out on the 8th. This was filed, so just 2 nights ago. This is a scheduling order. So scheduling orders are where you either have a joint agreement between the party, or if you don't have reached full agreement, you might have to do a phone or in-person conference to discuss what the cutoff dates for everything is. And maybe not everything. In this case, it's just the cutoff dates for some initial motion practice. Okay, so the procedural history here is Anas Abdin filed the complaint. He filed an amended complaint, and he filed a second amended complaint. The CBS, neither CBS nor Netflix have responded with answers at this point in time. However, they have had some correspondence with the judge laying out a request basically to dismiss the case, but not actually making a motion to dismiss the case. So that was weird. That's very strange with high-profile law firms, in my opinion. Maybe I'm wrong. I don't know, to go ahead and not actually have the not actually practice by motion, but to practice by letter correspondence. So who knows? Jira says hi chat, and then Jira says hi chat again. I don't know if that actually went through double. If it did, thank you, buddy. If it didn't, I don't know. And then Bagel Goose says shirtless stream when. I probably need some more sriracha vodka for that one. But okay, so anyway, so they've filed a second amended complaint. There was some correspondence from both parties to the judge. It seems like, and we're going to read those, but it seems like the CBS correspondence was trying to get the judge to just throw out the lawsuit without making a motion, which is, again, very strange. And then a response from Anas Abdin's attorney, John Johnson. He's responded and laid it out. And then they had their scheduling conference, which laid out the following. So, for the reasons stated at the conference held on January 8th, is hereby ordered that the plaintiff, that's Anas Abdin, shall file his third amended complaint, if any, by January 15th. So by January 15th, he must file another amended complaint if he wishes to make one. And he would make those changes based on the exchange that they had, the contents of the letters. Because if CBS brought up some initial issues with the claims made in the complaint, they would want to amend those and iron that out and make sure that their third amended complaint was the one that was ready to go. It is further ordered that defendants, this would be CBS Broadcasting, Netflix, and anyone else who's named. I don't know if there are any other named parties. We'll find out in a minute. Shall file their motion to dismiss, if any, by February 12th, not to exceed 25 pages. Plaintiff shall file his opposition to defendant's motion to dismiss, if any, by March 5th, not to exceed 25 pages. So, a good 24 days later, then 23. I don't know. What's math? What even is math? 20 days later? 21? Anybody? Doesn't matter. Not to exceed 25 pages. So he has, just over around 3 weeks to respond. Defendants shall file their reply, if any, by March 12th, which is another 7 days, not to exceed 10 pages. So that would be motion to dismiss, a memorandum in opposition to a motion to dismiss, and then a memorandum in further support of a motion to dismiss. Parties shall comply with the court's individual rules, including exhibit limits and courtesy copies. Always got to follow the court rules. Always follow the court rules, especially in federal court. They really care. And that's good. So that is from Lorna Schofield, U.S. District Court Judge. Important to note that when Lady Rackets and I were early in our marriage, we did have several mice, and one of them was named Lorna, which is a weird name. Don't encounter too many Lornas. So good job, Lorna, picking a name that I named a mouse. Yeah, so that's where we are. That's the procedural history. That's the status of the case right now. This order is the most recent document filed and is setting up what will happen in the next couple weeks. But the caveat to that is that this is, of course, just getting through the motion practice of the initial motion to dismiss. Will not be, the documents won't be in until March 12th, which means a decision will not be in until somewhere around April 10th to 12th, probably, on that motion to dismiss. So to give you an idea of the timeline, this is setting out the next 4 months in this case. Okay? Okay. And I think, I've got one thing to get. I'm over here. Sorry. 1 second. I went and got my stone cup from my other house. Finally. I've been without it for a while. So I'm going to have some Jameson. And then we're going to get into this. We're going to get into this second amended complaint here. We're going to have a jolly old time tonight. and we'll go. Oh, and full disclosure, I have spoken with Anas Abdin over private message. I've not spoken to him over the phone or anything. I have invited him onto the show for an interview. He has stated at the time that his lawyers were not wanting to have him do media appearances. So whether or not I will be able to have him on the show remains a mystery, remains in the air. I would love to interview him. Even if we don't talk about the lawsuit, I think anybody who dumps their life into creating a video game of this nature would be an interesting person to talk to, and I'd like to meet the guy, right? And I think some of you guys might like to meet him too. Of course, he has a case that brings him onto my radar and some of your radars, but that might just be a good way to introduce yourself to someone who's otherwise interesting. So I will, of course, after this video drops, follow up with him on the possible interview. I mean, he does speak about the lawsuit on his own blog, so he might be available to do it. This was several months ago, maybe 2 months ago, maybe 2 months ago, I believe that I spoke with him. And of course, I have no interest in impacting anyone's lawsuit in a negative way through an interview on my show, unless that someone would be like, someone awful. But I have reached out to him, and I will reach out again. I'd be happy to have him on the show. All right. So what's up, Yedarb? YDARB? Welcome to the show, buddy. All right, let's get to the second amended complaint. For those of you following at home, the SPLC lawsuit was an 85-page document. This is a 16-page document. There are several pages of exhibits as well. We should, in theory, be able to get through this one in a couple hours without any trouble. But, and we'll go through some of their exhibits and evidence. Oh my goodness. I made a mistake. I brushed my teeth right before streaming, and then I just drank a sip of whiskey. Ooh, that's conflicting flavors. So, yeah, we'll get through this document, no problem. Oh, another funny note about those SPLC videos. My first one, and if you have not watched them, I would encourage you to do so if you like the live stream format. The first one is monetized. The second one is under review. So mull that one around in your head, if you will. The first one is just fine. But the first one didn't even get a review. Oh wow. I just found that humorous. Okay. So, this is Anas Osama Ibrahim Abdin versus CBS Broadcasting and or CBS Corp and or CBS Interactive and Netflix Incorporated. So those are the defendants. Just the two. Plaintiff Anas Osama Ibrahim Abdin, through his attorneys, John Johnson Esquire and Alan Chan Esquire, complaining of the defendants CBS Broadcasting Incorporated, CBS Corporation, and or Netflix Incorporated upon information and belief sets forth and alleges as follows. Nature of the claims. They fear The first one, you were scared I would lose the channel forever. Who knew? Who knew? Featherbone bourbon, huh? Sounds delicious. Okay, nature of claims. Plaintiff commences the instant action, seeking damages and a permanent injunction due to defendant's infringement of plaintiff's duly copyrighted work, which is composed of text, artwork, and video, hereinafter the original work. Good subtle naming there. Plaintiff's final compilation of works was published in 2017. Plaintiff's original work actually became available to the public via World Wide Web back in 2014. Plaintiff holds a 2017 copyright in said works, registration number TX00085599280, as well as any subsequent filings, if any. That's Exhibit A. Thanks, Edarb. Catch you later, buddy. Have a good night. Plaintiff filed a prior 2015 copyright, which is not the subject of this action. Additionally, plaintiff being a resident of Kuwait, plaintiff received copyright protection in said works via the Berne Convention. So the Berne Convention is a giant treaty that almost every country on Earth is a party to. And the Berne Convention is how copyright protection is handled internationally, and it makes the substantive law between the works relatively similar. Doesn't mean they're identical. There are some differences that are country to country, as each country has their own laws, but the Berne Convention basically says that as an international community, we're going to agree to a set of substantively similar laws so that copyright protection can extend beyond borders. So you can't just have some guy in Jamaica redistributing all of the Avengers movies, right? I don't think Disney would be too happy if they did that. So there you go. Berne Convention, Universal Copyright Convention, and or Visual Artists' Rights Act. Plaintiff seeks damages arising from the defendant's infringement of plaintiff's copyrighted works, as well as other damages as delineated. Typo. Also, no comma after as. There should be. As well as other damages as delineated herein. Does not need a comma in it at all, buddy. What are you doing? Come on, John Johnson. The defendants are all active participants in the misappropriation of the plaintiff's work by including, without limitation, writing, holy cats, that's going to be hard, production, broadcasting, and or live streaming of plaintiff's copyrighted work. Whoa, that's hard to read. And continuing such infringement by creating a derivative work substantially similar to plaintiff's copyrighted work. If you followed along the Poppy lawsuit, I talked a lot about derivative works. When you have a copyright in an original work, you have a copyright interest in a protected interest in derivative works. So in Charlie Brown, if you were to make a Charlie Brown cartoon that was Charlie Brown and not fair use, right? Not significantly transformed, but was derivative of Charlie Brown and was meant to be Charlie Brown, then you wouldn't own that. That would be the original copyright owner would have to give you permission to do that. Okay. By creating a derivative work substantially similar to plaintiff's copyrighted work, the defendants incorporate plaintiff's copyrighted material in their work entitled Star Trek Discovery, which was first broadcast by the defendants on September 24th, 2017. The infringing work. The infringement continued in subsequent broadcasts when defendants incorporated plaintiff's work into a new character, which continues to appear in episode after episode to this day. Jurisdiction. Always got to have your jurisdictional argument in your complaint, and in federal court, you better make sure it's right. This court has jurisdiction over this action pursuant to 28 USC 1331, 1338, and 1367A, as they arise under the Copyright Act. 17 USC 101 et sec, the Act, and pursuant to the principles of supplemental jurisdiction and or extraterritorial jurisdiction of this court. So, of course, federal court has jurisdiction over disputes between foreign entities and U.S. entities or U.S. citizens. Additionally, this court has jurisdiction pursuant to Section 1332 in that the plaintiff is a citizen of Egypt and the defendants are U.S. corporations operating from headquarters in New York City, and the case in controversy exceeds $75,000. Venue is proper in this district pursuant to 28 USC 1391 et sec 1400A, in that the defendants operate corporate headquarters, sign contracts, and make corporate decisions regarding the infringing property within the jurisdiction of the Southern District of New York, resulting in continuous and systematic activity in New York. Said headquarters are principal places of businesses for the defendants. So if their principal place of business is in New York, then New York definitely has jurisdiction over them. He's a resident of Kuwait, Siren Jag, a citizen of Egypt. Resident of Kuwait, citizen of Egypt. The parties, plaintiff Anas Osama Ibrahim Abdin, hereafter Abdin, is a citizen of the Republic of Egypt and a resident of the state of Kuwait, having an address of P.O. Box 5969 Safat 13060, Kuwait. Defendant, CBS Broadcasting Incorporated and or CBS Corporation, hereinafter CBS, is a New York corporation. I'm sorry, it's really hard to read with that blue lit over the black. Is a New York corporation with a principal place of business at 51 West 52nd Street, New York, New York, and is the executive producer/producer of the infringing work and responsible for the broadcast and or streaming of the infringing work. At all relevant times, CBS transacted and conducted business within the state of New York. Defendant CBS Corp., aka CBS Broadcasting or CBS Corporation, is a Delaware corporation with its principal place of business at 51 West 52nd Street, New York, New York. It is a parent company which exercises dominion and control over all CBS programming and any deals to license any such programming, including without limitation its wholly owned subsidiaries such as CBS Interactive Incorporated. Defendant Netflix Incorporated, hereinafter Netflix, purportedly licensed the infringing work and entered into a contract in the United States with the CBS defendants to stream the infringing work online internationally, while defendant CBS maintained all rights to stream on broadcast in the U.S. Netflix operates corporate offices within the state of New York at 245 West 17th Street, New York, New York, continues to make the infringing work available internationally. By their acting in concert, Netflix engages in systematic and continuous acts which bear a substantial relationship to the copyright infringement. The international streaming of the infringing work is derived from the licensing agreement entered into in the United States, and purported second-generation copies of the work are derived from a U.S. master copy. It is through the CBS defendants and the interlocking agreements between the parties that allows Netflix to market and distribute the infringing work worldwide. All right. Testosterone Onion says Dominion. Well, they've got whips and chains and all sorts of ball gags in the Netflix basement or the CBS basement. Between May of 2014 and July of 2017, plaintiff completed and published several forum articles, artwork, and videos for a science fiction manuscript for an upcoming video game/game storyboard. While some of the content in these articles was factual, some portions of the article were changed or embellished by plaintiff. Plaintiff published these articles in Adventure Game Studio forums, and an astronaut blog, YouTube, Steam Games, and Reddit between May of 2014, July of 2017. That's the original work. Adventure Game Studios forum, hereinafter AGS, is a popular, widely disseminated online gaming forum with an estimated 1 million guests and users. Plaintiff's original works and the copyrighted work were available for viewing, playing, and or exposed to the AGS participants 24 hours a day, 7 days a week, including their family and friends. In addition, Plaintiff's storyboard, including videos, was distributed and watched by fans on YouTube. In the last 6 months, 28.88 billion visits to YouTube, not to his channel, and Reddit. Total last 6 months Reddit visits 1.49 billion. Exposing the game, storyboard, and artwork to millions more. Upon information and belief, the defendants access the plaintiff's widely distributed works. Plaintiff is the sole and lawful proprietor of all rights, title, and interest in and to the copyrighted original work, including within the storyboards. STD gave you spacey. The substantial, salient, and original aspects of the original work, copyrightable under the Act and the laws of the United States and or the Berne Convention, are as follows. The original work centers around a novel science fiction story centered on space travel facilitated by a fictitious larva-like creature with 8 appendages, a multitude of teeth, size larger than a human being, depicted with a blue hue, labeled the Tardigrade. The original work features a tardigrade with superpowers. These powers focused around space travel, especially at exhilarating or instantaneous speeds. These are very exhilarating speeds. Darkman McEdgeface says Guldakat did nothing wrong. Saavedra says the Poppy lawsuit created the precedent of don't copy that Poppy. There you go. How's your father? Asks if CBS's super lawyer is going to crush this guy. I don't think so. I mean, maybe they will in the long run, but they have not done so at the onset. They've made some weird procedural choices. We'll talk about them as we get there. I'm going to show you their work too. Don't worry about it. Exhilarating or instantaneous speeds. An essential element of the game, storyboard, and artwork include the tardigrade, featured floating in space, then moving through space at great distances instantaneously. The original work was in fact eventually named Tardigrade. See generally steamcommunity.com, which has millions of views per day. Plaintiff's Tardigrade and its abilities from the Tardigrades game, artwork, and storyboard compared with the Tardigrade character from the Defendant series are strikingly and or substantially similar. Additionally, prior to Plaintiff's original work being exposed to millions online, no other Star Trek series featured a single Tardigrade being used for space travel or to power a spaceship. And that is important. That is important. Shockingly efficient. This is the lawsuit from Anis Abdin versus CBS. Anis Abdin has created a game called Tardigrade, a video game, and it appears that the Star Trek Discovery show may have, quote unquote, borrowed heavily from that work. So that's what we're reading today. In subsequent episodes of Star Trek Discovery, the defendants began using Tardigrade's DNA, which was injected into a crew member as the means to navigate their spaceship. This change thereby creates a derivative work since it was based upon the plaintiff's original work. Additionally, the chamber in which this injection of tardigrade DNA takes place, is this tardi-rape? Is that what happens there? Is also strikingly, let me give you a DNA injection. Every time they go into the chamber, is also strikingly and or substantially similar to the original original work. See Exhibit B for examples of the similarities. This type of fictional space travel based on tardigrade instantaneous travel is utilized as integral to the plot of each and every episode of the infringing work. This fact is borne out in an article in Screen Rant magazine, in which the author states that the introduction of a new, this is a quote, the introduction of a new alien species that is rather unlike anything seen before in Star Trek. See also Exhibit C, articles from Popular Mechanics and TV Line touting the importance of the tardigrade to the Discovery series. You think Tardigrade is something else? I think so too. The original work features a main character being absorbed into the tardigrade, becoming one with the tardigrade, and having the tardigrade's abnormal powers. Plaintiff's original work revolves around a gay relationship between two male homosexual main characters. Well, I think it'd be more interesting if it was a gay relationship between two heterosexual main characters. One is depicted in the game storyboard and artwork as an albino male with a dark complexion. As an albino male with a dark complexion male with sideburns, mustache, and beard. Okay, sorry, I read that. They should this sentence, guys. If you happen to see this before your third amended complaint, restructure that sentence, please. It's an abomination. An albino male. I read it as an albino male with a dark complexion, which makes no sense. But they're meaning the albino male is in the relationship with a dark complexion male with sideburns, mustache, and beard. Concomitantly. Okay. The defendant series include the exact same characters with striking/substantial similarity. If they're the exact same, then they would have striking or substantial similarity. I think you mean, I don't know what you mean. I know what I saw, and it makes sense when you know that, but this sentence, Annis, if you're watching and if your lawyers are watching, paragraph 17 is worded in a very confusing way. I think you could use a little workshopping. Christ Raisin. No, this is not a fan fiction. That's the interesting thing here. This guy created an original work, and it looks like Star Trek Discovery may have taken his original work and inserted it into the Star Trek Discovery show. Okay. The facts there about his work being available before Star Trek Discovery are quite true. I knew of this game well before I heard of Star Trek Discovery coming out, says Wolvenar. Yeah, I mean, 3 years. I mean, his game had been available, or like the artwork and the concepts for his game had been available for 3 years prior to Star Trek Discovery's release. Okay, anyway, Advocate Magazine, which is widely disseminated within the LGBTQ community, states that the defendants made history by introducing an openly gay couple into the Star Trek universe. This concept is a major part of the defendant series and is also a major part of the original work. Entertainment Weekly also touts the brilliance of the defendant's infringement by the first introduction of such a couple in its 51-year history. IndieWire states that Star Trek did not bury its gays. Well, what'd they do? They left their dead gays sitting out? Don't leave the gays out. They deserve burial too. Oh my gosh. Can you imagine? Just because of your sexual orientation, you don't deserve to be buried? That's horrible. Again, this storyline was introduced in the original work. The original work features uniforms which delineate status, rank, etc. Again, defendant's infringement includes uniforms which are strikingly/substantially similar to the original work. Heretofore, the Star Trek series has not used any uniforms styled or colored in this manner until Plaintiff's original work was published. In fact, the infringing work's uniforms are a total departure from prior Star Trek uniforms and represents copying of the original work. Other substantially similar characteristics include... No period after paragraph 17. Yeah, 17's a mess. 17's a mess. Thanks for pointing that out. The original work also concentrates on a main character, blonde white male with similar characteristics as the infringing work, who is a space botanist, a person who specializes in space plants. The defendant focuses on a main character who is a science officer with an expertise in astromycology. This fictitious word is defined by the defendant as a study of space mushrooms, which is substantially similar to the original work. Oh yeah, astromycology. That makes sense. It's a fictitious word, but it's a good fictitious word, because once I realized that it's about space mushrooms, that it actually It does. It makes some sense. Good job. Here we go. Here we go. Bring out your gaze. The space botanist thing is kind of interesting for both of these. Because wasn't Matt Damon in The Martian? And of course the Martian book coming out before the movie. Wasn't that character was a botanist on Mars. But he wasn't a space botanist. He was a botanist who was in space. Little different. The original work features fictional character named Aziz, a darker complexion homosexual male with black hair and a short boxed beard, facial hair consisting of trimmed sideburns, mustache, and a goatee. Good choice of facial hair, I think. Actually, no, it isn't, right? Needs more beard. The original work features fictional character named Carter, who is a blonde white male who is a space botanist. The original work features a fictional character named Yolanda, a female of African descent with messy curly hair. Little racist, if you ask me. That's a joke. The original work features fictional character named Natasha, a white female with orange curly hair. Hello, Natasha. She's okay. Orange curly hair is okay. The original work features Egyptian cultural influences and elements specifically throughout the series. The original work features an Egyptian spaceship that emits signals in the form of light beams called the emitter. The defendant's first episode includes a spaceship called the sarcophagus, surrounded with Egyptian-like coffins which emitted light signals. The defendant's Michael Burnham character, during one scene, called the light beam from the sarcophagus a signal emitter. Uh-oh. Let's see. The original work features... Oh, man. My back itches right in the middle of it. The original work features a scene of the Tardigrade traveling through space unaided by any external technologies. The original work features a scene with imagery of Carter. And there are pictures to back all this up and support it. We're going to go through those when we get through the document. The original work features a scene of the Tardigrade traveling through space unaided by any external technologies. The original work features a scene with imagery of Carter, a blonde white male space botanist surrounded by a glowing blue light with scattered white light particles. The only human character in defendant's work, Paul Stamets, a blonde white male astromycologist, navigated space within a chamber surrounded by glowing blue light with scattered white light particles. The original work features a scene with imagery of a character traveling within an astroplane environment. I don't know, shouldn't that be PLANE? Appearing as space with stars having echoes of said person traveling himself. The defendant's work features a substantially similar scene wherein there's background of a space-like astroplane with a main character seemingly traveling with trails of themselves behind them. I think they mean PLANE. If my Magic the Gathering is correct and my Dungeons and Dragons terminology is correct, the plane they're talking about would be a geometric plane, not a whatchamacallit, ecological plane. So you probably want to change that to PLANE. Yeah, where are the Necrons? We was Necrons. 40K should just sue everybody for copyright infringement. Let's see those tardigrades stand up to the green beams of the Necrons. The relentless assault of the Undying. Oh man, that makes me want to play some Dawn of War 1. Again, the original work features physical details, abilities, and functionality of tardigrades that have not been published or utilized by anyone else until the copying by the infringing work. The appearance, color, size, and abilities are essential elements lifted from the original work, which are now essential elements of the infringing work. Characters of the original work are also are strikingly / substantially similar to the infringing work in both physical details and functionality. Is gayness a functionality? There are fictional characters, aesthetics, and reworked narratives that are unique to the original work that appear in the infringing work. The infringing work captures the total concept and feel, as well as the artwork and characters. These characteristics have never been used in the Star Trek series or films, and the basis for their inclusion now is due to the infringement of the defendants. So what they're setting out there, and this is important, if these were a logical extension of the Star Trek universe, he would have a much, much weaker claim. Much weaker. Whatever his claim is, strong or weak, I'm not really sure yet. Whatever his claim is, it would be substantially weaker if there was, references in some other Star Trek show to the Tardigrades or to the Tardigrade that could travel through space if they only got a hot DNA injection on a Saturday night from it. If that had happened, if Picard had romanced a tardigrade or two and then traveled through space, then we'd have some trouble. But because they're really outside of the Star Trek scope, that really does solidify his case a little bit. How do the Beastmen combat Khazar milkers in Warhammer lore? I have no idea. Plaintiff's original work was made available to the public since 2014 via various gaming portals, as previously asserted, and including without limitation. Discussion of this fact can be had at http. This is all a clever advertisement for his blog. anastronaut.blogspot.com. News of the defendant's infringement was highly publicized on the internet. One such article highlighting the plagiarism of plaintiff's game at Rock, Paper, Shotgun was published very close to the time of the defendant's release of Star Trek Discovery. Rock, Paper, Shotgun has approximately 14 million visits to their site. Purportedly, said article prompted the vice president of legal affairs to contact plaintiff. Plaintiff's counsel discussed the matter with the CBS attorney. This discussion was not for any settlement purpose. The call was wholly designed to discourage the plaintiff from taking legal action for infringement. Plaintiff was told that his original work was safe. CPS would not sue him for infringement, and that is critical. That is critical. If that fact right there, because this is one thing I was thinking of, is that if this guy's work, let's say he made the game, even though he'd been working on it since 2014, let's say he'd made the game in 2018, right? And put it out. Would CBS sue him? Would CBS sue him for infringement? Interestingly, they've said they'd not sue him for infringement, that his original work was safe. That's really interesting. There's two possible ways that it's safe, right? One is it's safe because we're not going to pursue legal action. One, because we hope you won't. Or two, it's safe because it wouldn't be an infringing work because they're so significantly different that they couldn't possibly be infringing on either copyright. We wouldn't sue you because we wouldn't have a chance. It's impossible to say what the nature of that call was from this sentence. However, they seem to be, they're going to play it up for their side. And I think this is an important question. Had none of the lawsuit occurred and he released the game, would CBS have gone after him? That could have been great. That might have been a better course of action in some ways. Had he released his game, CBS sued him for infringement, and then he countersued them for infringement. Oh, that would have been devastating. Such an unethical and subtle threat demonstrates the level to which defendants were willing to descend. The threat not to sue was made notwithstanding the fact that plaintiff's game artwork and storyboard had been widely disseminated prior to the conception and or airing of the infringing work. Conversation ended with an assurance of a second call, which never transpired. Took you long enough to jump on this case, Bryce. Just kidding, buddy. It's been on my back burner for a long time. And then it felt weird to do it, but with the recent announcement just 2 days ago on the blog. I felt like it was a good time to jump on. But as I stated before, I've spoke with Anas Abdin in some private messages months ago, asking to do an interview on the case. But without being able to connect on that interview, I was kind of holding off on a video. So I spoke to him, and at the time he was not ready to come on the show. Maybe he will be after this. I don't know. We'll see. We'll see. Here we go. Plaintiff created the original works by working from a storyboard which he created. Plaintiff created all the artwork and or designs, concepts, and storylines prior to Star Trek Discovery and posted this original work on the internet. As outlined herein, defendants infringed inter alia plaintiff's artwork and or videos, violating additionally his moral/vara rights in said works. Moral/vara rights in said works. In addition, the defendants violated the plaintiff's rights of disclosure, attribution, and or integrity. As for a first cause of action, permanent injunction. This one is a good luck. A good luck. Getting a company like CBS to stop broadcasting a mainstream broadcasted show mid-run. Good luck on that one. Better to get money, I think. But you ask for the injunction, but better to get money. I don't know, shockingly efficient. We'll see. Plaintiff restates and realleges each and every allegation contained in this complaint with the same force and effect as if fully set forth herein, of course. Plaintiff is the sole and lawful proprietor of all rights, title, and interest in and to the copyrighted original work. Defendants had access to the original work by virtue of the original work being published with millions of views. Millions of potential views. We don't actually know that millions of people viewed the original work. Maybe they did, but in their fact section, they did not properly establish that. They established how many views the websites got, right? Like they established that, but they didn't ever lay out how much traffic his blog got and how much traffic the specific threads about his original work had gotten. Maybe it was millions. I'm not saying it wasn't, but I think they need to, in their amended complaint, if they can support that with hard data, it'd be better. Hard data is better than soft data. Defendants, without plaintiff's authorization, knowledge, or consent, willfully infringed on plaintiff's original work by causing to be written, produced, and broadcasted on live television and streamed via an on-demand streaming service, including without limitation DVDs, a derivative work entitled Star Trek Discovery, the infringing work, which is substantially similar to plaintiff's original work. Accordingly, defendants have infringed plaintiff's copyright in the original work in direct violation and contravention of 17 U.S.C. 101 et sec. And 106 et sec., including without limitation, VARA and or the Berne Convention. Plaintiff seeks impoundment of all copies of the Star Trek Discovery series and seeks to bar defendants from infringing on defendants' right to license said series. That'd be funny if they granted the impoundment of all the copies of the Star Trek Discovery series. Because could you just imagine like them having to ship something like 50,000 DVD box sets to this guy's house in Kuwait? Like, here's your shipping container full of DVDs. Boom, just drop it on his property. Oh, that'd be funny. Plaintiff will incur substantial and irreparable injury if defendants are allowed to continue their infringement of the original work pending the resolution of this action. That's true. Just makes the cash award bigger. By reason of the foregoing, plaintiff is entitled to a permanent injunction pursuant to 17 U.S.C. 502, enjoining and restraining defendants from further infringement or broadcast of plaintiff's copyrighted original work. As and for a second cause of action, actual damages for copyright infringement. These would be massive. Plaintiff is the sole and lawful proprietor of all rights, title, and interest in and to the copyrighted original work. Defendants had access by the virtue of the original work being published with millions of views. Defendants, without plaintiff's authorization, knowledge, or consent, willfully infringed on plaintiff's original work by causing to be written, produced, and broadcasted on live television and streamed on an on-demand streaming service, including without limitation DVDs, a derivative work called Star Trek Discovery. There should be no apostrophe in DVDs. The infringing work, which is substantially similar to plaintiff's original work. You should have an "and" after DVDs. Because your list doesn't keep going, it's only 2 items. You should just have an "and" instead of a comma separated list. Come on, John Johnson. Learn to English a little harder. Accordingly, defendants have infringed plaintiff's copyright in the original work in direct violation and contravention of 17 U.S.C. 101 and 106. By reason of the foregoing, plaintiff is entitled to actual damages and profits pursuant to 17 U.S.C. 504B and or VARA in an amount to be determined at trial. Also, statutory damages for copyright infringement. This is the third cause of action. Some good whiskey. Okay. I'm going to skip through several of the paragraphs here because those paragraphs I've read twice now. Let's see. By reason of the foregoing, plaintiff is entitled to statutory damages pursuant to 17 U.S.C. 504C1 in an amount not less than $750 or more than $30,000 per broadcast of the infringing work as statutory damages, and or pursuant to 17 U.S.C. 504C2, the sum of $150,000 per broadcast of the infringing work as additional statutory damages pursuant to 504C2. That's brutal. That's a lot of damages. Especially because I think Netflix broadcasts would count per stream, which would be off the charts. Off the flippin' charts. One broadcast on CBS will reach, thousands of people. One broadcast on Netflix is like 1 to 8 people. So that'd be interesting. CBS also has a streaming app. I don't know if this is available on the CBS streaming app. But if it is, that of course would then be, each one of those I believe would be a broadcast. Additionally, plaintiff is entitled to statutory damages by virtue of defendant's violation of plaintiff's moral rights pursuant to the Berne Convention and or Visual Artists' Rights Act. As a fourth cause of action, attorney's fees and costs. So the same basic premise here. Plaintiff is entitled to attorney's fees by virtue of the defendant's violation of plaintiff's moral rights pursuant to the Berne Convention. By reason of the foregoing, plaintiff respectfully requests a recovery of all costs as well as attorney's fees in connection with prosecution of this case pursuant to 17 U.S.C. 505. Constructive trust. By virtue of their wrongful conduct, defendants have illegally received money and profits that rightfully belong to plaintiffs. This is brutal. If all of this were to go through, it's absolutely devastating to CBS, and that'd be funny. Defendants hold the illegally received money and profits in the form of bank accounts, real property, or personal property that can be located and traced. Defendants hold the money and profits that they have illegally received as constructive trustees for the benefit of plaintiff. They should include in this cause of action a demand for all of the property to be turned over to plaintiff. I think, stylistically. Sixth cause of action, accounting. Pursuant to 17 U.S.C. 504, plaintiff is entitled to recover all of defendant's profits attributable to their acts of infringement. Pursuant to 17 U.S.C. 504, plaintiff is entitled to recover actual damages sustained by virtue of defendant's acts of infringement. The amount of money due from defendants is presently unknown to plaintiff and cannot be ascertained without a detailed accounting by defendants of all profits obtained from their marketing, distribution, national television broadcasting, and or streaming of the infringing work. Wherefore, the plaintiff respectfully requests this court to enter a judgment against the defendants for their willful, malicious writing, producing, and broadcasting. Okay. Criticism. Willful, malicious. There's a comma there. There's not a comma after malicious. There should not be a comma after malicious. Writing, producing, and broadcasting on live television and streamed on on-demand streaming service. That should be a comma after television. Including without limitation. Actually, they should semicolon delineate malicious writing, production, and broadcasting on live television. Semicolon after television. And then a comma, including without limitation, comma, DVDs of a derivative work entitled Star Trek Discovery, the infringing work, which is substantially similar to plaintiff's original work, which resulted in and continues to result in injuries to plaintiff. Accordingly, plaintiff respectfully requests that this court, there you go, have an English major look this over, guys, because it needs a little polish, in my humble opinion. Issue a permanent injunction against the defendants and all others in active concert or participation with defendants from further broadcast/streaming of the infringing work or other infringement of plaintiff's protected copyrighted original work. Order the defendants to recall and destroy all copies of the infringing work or any other derivatives of plaintiff's original work in whatever form they may exist. That's not going to happen. Could you imagine the judge ordering everyone to return their DVD copies of Star Trek Discovery? That'd be hilarious. Won't happen. Order defendants to pay plaintiff an amount to be determined at trial in actual damages and profits plus interest pursuant to 17 U.S.C. 504B and or VARA. Order defendants to pay plaintiff not less than $75,000 or more than $30,000 per broadcast of the infringing work as damages pursuant to 17 U.S.C. 504C1. Order defendants to pay plaintiff the sum of $150,000 per broadcast of the infringing work as additional statutory damages according to or pursuant to 17 U.S.C. 504C2 or such other amount pursuant to the violation of plaintiff's rights pursuant to VARA. Order the imposition of a constructive trust over defendants' profits which resulted from their infringement of plaintiff's original work. Order that defendants provide plaintiff a full and complete accounting of all profits obtained from their marketing, distribution, streaming, and national television broadcasting and or any other sales of the infringing work and any other amounts due and owing to plaintiff as a result of defendant's infringement, and grant plaintiff such other and additional relief as the court deems just and proper. Demand for a jury trial. Definitely do a jury trial. There you go. That is the document. Who knew? Who knew that you could make a cognizable claim in 16 pages? Hey, every other lawyer on earth, listen up. The SPLC lawsuit, of course, was 81 pages. This being 16 is very refreshing. It is to the point. It lacks narrative. It doesn't require narrative. Copyright operates by strict interpretations of the statute in many ways. The only thing they will need to establish is, of course, the question of fact of whether or not this is an infringing work. It doesn't matter the virtue and goodness of the parties involved or the badness, right? The SPLC lawsuit that we just read over the past 2 days involved a lawyer accused of being a racist, very much trying to convince the court that he was not a racist, and very much trying to paint the SPLC, which is a horrible gaggle of degenerates who may all deserve the fires of hell. Unironically. But painting them as horrific, monstrous, stalking, job-killing ghouls, which they are, but going to great lengths to explain it. Bagel Goose says, read it again. No, instead of reading it again, what we're going to do is we're going to go ahead and read the other documents in this. Siren Jag says, hard data is better than soft data. Just ask Lieutenant Tasha Yar. Oh, wait, you can't because she's dead. Wow. Wow. Let's check out some similarities, right? See what exhibits we have. First, we've got the copyright registration. Pull this up. So this is the title of work. Look at that. Get a scanner that keeps the document straight. What is this? This is probably done. Oh my gosh, what a disaster. Title of work is Tardigrades. Year of completion 2017. Date of first publication July 12th, 2017. Nation of first publication United States. Anis Abdin created text and artwork. Was work made for hire? No, he made it of his own volition. Citizen of Egypt, domiciled in Kuwait, born 1978. He's the copyright claimant. Kuwait University College of Computing Sciences and Engineering, Information Science Department. Material excluded from this claim, text. New material included in the claim, text and artwork. He did say that he had a prior copyright in 2015, but that was not the subject of the lawsuit. Without knowing what's in there, I have no idea why they would go ahead and do that. The effective date of registration is June 28, 2018. This is mildly important. He did not have a copyright, or he had a copyright very briefly prior to filing this suit. Let's see if I can. Complaint was filed August 19th, 2018. So he had discussed this. He had discussed this claim with his attorney, I'm guessing. And what happened was the attorney said, go ahead and file the copyright June 28th. Then we'll proceed with the lawsuit, which was filed August 19th. That might impact his ability to recover statutory damages. Off the top of my head, I don't know, but I do believe that the copyright has to be filed within a certain time frame of the infringement. There's a rule around that, and I don't know it off the top of my head. I apologize for not knowing it, but, you know, I'm not a copyright expert by any means. But he does have a registered copyright, which may entitle him to the statutory damages. Without a registered copyright, he would not be entitled at all. The question is whether or not he is within the statute for getting that registration done. Next. Let's look at his copyright filing. He needs to know his lawyer can't punctuate properly. I tilted the page on the projector. Yes. Yeah, he does need to know his lawyer can't punctuate properly. Hopefully, either he or his lawyer will watch this video and take it as only positive and constructive criticism, my friend, because I would love to see the indie game creator win against the corporate juggernauts of CBS and Netflix. My personal opinion is it really does look like they stole this guy's work. Okay? It really looks like they stole this guy's work, and I don't want something dumb like punctuation, which is a minor complaint, and the judge probably isn't going to care because they're going to know what's going. They're going to know what they're after, right? But it's minor, and I would if you have the opportunity to amend, I would amend and correct the typographical issues. So here is the copyright filing. Tardigrades. This would have been submitted to the Copyright Office. Tardigrades by Anis Abdin. In our understanding of time, it is the year 20,000 BC, where civilizations are about to discover intergalactic travel using their latest technologies. Earth was different back then. The deserts of South Egypt and Ethiopia are green and full of advanced technology. This is going to be, of course, that part is substantially different than the Star Trek Discovery timeline. Pictured at right, tardigrades are organisms known for their high resilience among known animals. They can survive temperatures from the absolute zero up to above the boiling point of water. They can survive higher doses of radiation and vacuum and the vacuum of space. Carter is a botanist at the space station Mars E3 orbiting Jupiter. Along with his girlfriend Alex and your guidance, they might be able to witness their civilization shifting into a higher type. Tardigrades can be finished with different ways. There are 2 possible endings and tens of ways to complete its puzzles. Each time the game starts, it's guaranteed to be a new experience due to some events and puzzles triggered randomly at any time of the gameplay. Story depends on your attitude and dialogues, tasks, choices, and/or random events. So basically, you'd be writing the story of the game. The story has a plot twist and deals with slavery, secrecy, and espionage. Which, joke about Egyptians, Bible joke about Egypt. Here is the space station. The top right, the isometric, and the bottom view. A full 3D sketch of the orbital station Marzi 3. Left, Aziz. Aziz is trying to ease the situation after Carter mentions the recurring dreams he has been seeing lately. Same old dream, fam? Right, Carter, age 34, Earth, solar years, class 4A, botanist, Marzi 3, Jupiter orbit. Carter is devoted to his work. He's been passionate about plants since his childhood years. He graduated from Thinis University. Currently, he is responsible of the 4th Oxygen Garden at Marzi 3 with his lovely girlfriend of 2 years, Alex. Left is Aziz, who's a 35-year-old class 4D technician. Aziz is the pneumatic technician on Marzi 3, always rushing to fix any problem within the system. Aziz's boyfriend is hundreds of miles away on Titan. Communications seem to be a problem due to solar activity within the region, along with Jupiter's magnetic field. He is coping with this situation by playing his favorite music instrument, the recorder. Oh, kill him. Kill him immediately. Like, we may have progressed past killing gays, but killing recorder players is still mandatory in all civilizations. Gojirify says fireball. Fireball. No. Fireball is disgusting and horrible. Mayday, mayday, we're in big trouble. Someone attacked our only oxygen reservoir in the crystallized ammonium silos. 2 of our crewmen got killed trying to escape. We need to do something. Who's this guy? That's what I want to know. Who's a short, weird looking guy? Right is Yolanda, age 26, Earth years, communications engineer. She's class 2B. I don't know what the classes matter, or what the classes are. Yolanda is a communications engineer on Marzi 3. She is responsible for all interplanetary messages sent and received to and from Marzi 3. I hope Intergalactic is playing during the entire game. Yolanda doesn't have an office aboard the ship, which seems racist and sexist to me. She keeps wandering around Marzi 3's rooms and corridors, making sure everything is under control. Yolanda is a unique character. Whenever she's in a room with another NPC, you can always invite her to a 3-way chat. Huh. Wow. Seems like Yolanda's a little loose on the chats. Left is Moon. 38 years, class 2A engineer. Moon is an engineer. Working along with Kat, they make sure the engine temperatures are within nominal ranges. Despite being diagnosed with Down syndrome, Moon showed higher IQ levels than his colleagues and aced his engineering school back on Earth. So apparently, the Down syndrome Moon here. Oh, man. Ty, right is Ty. Age 120 Mercurian solar years. He's 120 years old on Mercury, which makes him like 8 in American. Occupation chemical engineer. AS methane storage. Oh, that's where he is. No, methane storage facility is where he's working. T1453 location Titan. Ty is responsible for the storage of the metallic ammonium in the silos on Titan. Making sure the conditions are perfect for the metal is not an easy task due to the gravity weakness of the Saturnian moon. Ty is Aziz's boyfriend, born and raised on Mercury. He is more of a fan of colder climates since he spent most of his childhood on the cold, dark side of Mercury. His application to join the crew of Marzi 3 was rejected due to hatred of gays. No, to an incident that is clearly stated in his record. He managed to get a job on Titan instead. Left, Natasha. Natasha's first appearance is on Titan. She's on the Iram team, which is the major rival against your nation. What was she doing on Titan and specifically on land owned by your team? So the Russian chick's the enemy. Got it. And will she be able to buy her way out? Are you going to be more than friends with her? Wow. Maybe at least to get more information about what she was doing on Titan. So you bang the Russian chick for information. There you go. That's how this works. Oh, I love it immediately. What about Alex? Will she be okay with the situation? Well, yeah. Will Alex be okay with you fooling around with the Russian redhead? It's just for information, baby. Don't worry about it. It's just for information. You've got a lot to explain, Carter. Just be careful about the women of Iram. There's a big monster lurking behind their beauty. Oh, it's a trap. Oh, it's a trap. Whew. Sorry. There's some images. Some naked guy with a bunch of blue and white dots. I don't know what's going on there. Might need to clean up after that. Left. Masiek is going to be a very interesting NPC in Tardigrades. Player will be able to take control of him in an unconventional way. There's many jokes. The jokes increase. The jokes increase as the liquor increases, I think. His actions can be triggered in several ways. Oh no! He's a male feminist. I'm just kidding. Just kidding. His actions can be triggered in several ways. Either by mental manipulation and or verbal insults. Right. Control mechanics behavior by changing his character's mood. Variable Mac mood. You can force him to be a little nicer to others or not. Go. Why is he shirtless? I'm so confused as to what's going on here. Here's the game screens. Looks like one of those old like Beneath a Steel Sky. Beneath a Steel Sky, I think was and like King's Quest and stuff where you had a 2D sort of game with a lot of pointing and clicking and then some interactivity of the characters. Ethereal Space. There's no label on this first one. Queen's Palace. We got some Egyptian iconography here. I don't know if the queen is... I don't know if she's wearing see-through, but kind of looks like it. Oh, apparently we've got the queen in blackface right here. So she's racist. I really don't mean to make fun. Annis, if you're watching, this is all these jokes are in good fun, buddy. I think you I really do from what I've seen so far, and we're going to get to those comparison screens in just a second. I think you do have a case. Just having a little fun with some of this stuff. Like particularly this picture of the Tardigrades, Tardigrade or whatever, whispering sweet nothings into the naked man's ears. He's in his uniform feet here, and then he blows his socks off with some hot language. And then this, I can only assume, is when he reaches absolute climax. Absolute. Here we go. Here's the Tardigrade. Given the rear naked hug to this guy. I don't know. I guess it enfolds around his face. And then it kind of absorbs him. And it teleports. Oof. All right. I remember the day Dad took me to the pond like it was yesterday. I had so many questions. He answered every single one profoundly. Well, that's profound. Each answer led to more questions. This should go on Wikipedia. He was very passionate about teaching me what he knew, always eager to hear more questions. He used the simplest elements for illustrations. Foo, fa, foo, roar. One of the days we were out was different. He was silent. Although he deliberately avoided eye contact, his heartbeat was saying one thing. I love you, son. What? What? Come, sweetie. Don't you want to join mommy in the pond? Mommy is apparently a naked MILF in the pond. Show me what you got there. Alex, no! Licking the hand of the pond scum, I guess. I don't understand what's going on here. I'm really confused. You can't just eat anything you find. Let me show you something. She's still naked. He's in a diaper at least. This is home. For so many little creatures, even though you can't see them, they are the strongest we have discovered. That's the tardigrade. They're too tiny, about 0.5 millimeter when fully grown, yet they have 8 legs. Doesn't matter if it's too hot or too cold, they can withstand extreme temperatures between negative 458 Fahrenheit up to 300 degrees Fahrenheit. They can survive the vacuum of open space and solar radiation combined for at least 10 days. When exposed to extreme low temperatures, they dehydrate their bodies, which consist of 83% water down to 3%. Tardigrades are the first known animals to survive in space. And then he went to a public school long after the purge. Government purge of all people in public school. Checking out this chick, I guess. Or maybe he's just not interested. Then why do you think he keeps looking at our direction? I meant maybe he's just not interested in you. Uh-oh, so chicks are normal back then, always in competition. He's apparently a rugby player, grunt, but I'll be a darling and leave him for you. Why, thank you. I like the bearded dude. Now he's the one. I'm sure he's into me. Uh-oh, watch out. Pretty sure bearded dude's the gay guy. Dude, just ask her out. I don't know why. I don't know. I'm kind of shy. If you don't ask her out, then I will. Bunch of shaving cream. Rip beard guy from Walk Off the Earth, by the way. Hey, not cool. Relax. She's not even my type. You are. This is some bloody stubble, I guess. Following the shave. That's kind of weird. Anyway, I'll be generous and pass her on to you. Speaking of generosity, I'd like you to have this puck. He threw a hockey puck at his head? Jeez. Swoosh. Thud. Want to join the hockey team? Sorry, my buddy and I were goofing around. Here is your puck. Okay. Got gauged ears, face tattoos. This guy is definitely not safe for children. Coming from a modest family means less activities and summer vacations. I don't know how, what, I don't even know what's happening here. This is interesting. Coming from a modest family means less activities and summer vacations. Most of our friends traveled, moved to summer houses or summer camps. Alex used to read a lot. Alex has a booty. We can see she's got thick booty, shorter or like thinner legs going down. She is rocking the trunk though. She gets immersed to a point she doesn't feel her surroundings. I tend to seize those precious moments. Been saving for ages for this moment. Hands are like a golden rose here. Not even looking. Oh, it's got a ring on it. You listen to Destiny's Child. Any relevance? This is mildly relevant. This is the copyright filing, right? He's including the entire copyright filing. It's showing the art style. It's showing the characters. It's showing all of this stuff. He did not. Well, I mean, he kind of filed this with intention to file the lawsuit, but in general, he's going to protect all of the work. So he's going to put in the stuff that he's released. He wants copyrights in this stuff. So of course, I'm just jokingly going through it. A lot of this stuff is not really relevant to the lawsuit. But we're almost done. There's only 2 more pages of copyrighted work, and then we're going to move into the comparison screens and some of the articles. Are we reading some weird comic? Kind of. It's a video game script. Question? Oh my God, Carter, what did I tell you about picking roses? I thought you killed the poor thing. So she's a vegan. Oh, relax. Should have seen your face. Oh. Kind of looks like James Vanderbeek in that picture. Oh, it must have cost you a fortune. Well, look at the size of that ring. That's a whole hand of ring. That must be a bracelet. I love it. Oh, it is a bracelet. Holy cats. It was around that rose at first. Oh, but I guess it was big there. I just didn't realize it. Okay, yeah. It's a giant bracelet. It's not a wedding ring, I guess. Thank you, honey. Kiss. Weird faces. That's the end. That's the end right there with those 2. Sun flare. So what happens next is up to you. Other people went out for summer. Alex and I stayed home. All right, now here is the similarities. So these are some of the artwork and concepts put up next to screenshots from Discovery. Hey, what's up, Stream Me guys? I see you in the chat there. Thanks for joining me. Glad to see you guys on there. Of course, you're not showing up. Stream Me chat just does not interact with the restream chat, and I apologize for that. But I will, now that I know you're over there, I'll watch there a little bit better. Duff Guy says this would probably be a decent porn plot. I think so. Okay, so this is the similarities between the works. What's interesting to me is that Aziz is a bearded homosexual who is in a relationship with an albino dude. That's the first thing here. He bills Aziz as like a brown man, not a white man. And but the picture, I'm not getting the brown as much here. And this is, of course, a very light-skinned individual over here, too. So maybe not. I don't know. But he comes across as white in the artwork, if I had to make a minor criticism. So this is Aziz's face. So this is Aziz in the original work. This is the comparable character who is also gay, who is in a relationship with, well, I don't know if he's an albino blonde, but we'll find out. Ethereal space. The background changes as one enters it. Character leaves a trail made of projections of the previous frame. So to explain this, we've got, the character's feet, right? Then he starts to get naked. Then he's getting climaxing from the Tardigrades rape that's occurring there as he's entering ethereal space and then becoming someone who can travel through that ethereal space faster than the speed of light. And if you notice, there are little silhouette outlines as you move through that ethereal space. Okay. So then the comparable scenes in Discovery, this guy apparently got a Cosby tardigrade and is knocked out. Then the Cosby tardigrade has inserted itself and is now commencing the pillaging. And then here is the trailing effect that is highlighted as he enters ethereal space. In all honesty, jokes aside, this is pretty similar, right? We don't have the purple background, but like the idea of what's happening here, like this phase shift through the elements, at least as it's presented, unless it's disingenuously presented, it is pretty similar. And the trailing background and sort of the weird off-colored look, and the nudity, because like he's in his uniform here, but here he seems to be, I don't know, he's got some sneakers on, it looks like, I'm not sure. But yeah, so that is that. I mean, that's not enough for a nail in the coffin or anything, but that is strikingly similar. And let's see, homosexual relationship between Aziz, brown black bearded, and Machiek, albino blonde. So here's Machiek, the albino blonde. He's got some monstrous mutton chops here that are not present on this guy who probably can't grow mutton chops. But we do have a gay relationship between this character and this character and this character and this character. So apparently the interracial gay is a thing. Machiek, albino blonde, homosexual in relationship with a black bearded man. So there you go. These two, I guess, making similar faces. That's probably why they picked that screen grab. Next, Natasha. Long, curly, orange, red hair. Here's Natasha. Here's a chick with a giant mole on her head, who also has red hair. The problem with this part is we don't know if there's any similarity. Is this chick an antagonist? Is she Russian? What other similarity? I don't know if Natasha's technically Russian, but does she share other creative traits, or did they find a redheaded chick to throw in the pictures? That's a different question. It's not really laid out in the complaint. Again, if I have a criticism of the complaint, it would be to further tie the Natasha character into whatever random up-and-coming mole-headed starlet this lady is. Carter, botanist, inside space blue lit travel chamber filled with floating white dots. That's here. Of course, he has to be naked in this one for the Tarda rape. And then here, he's in this space chamber filled with some questionable white material. I don't know. Maybe it's the set of a... Maybe he answered the wrong casting call. I'm not sure. This is called the Spore Drive picture. That's awkward. Disgusting. Here we go. Giant blue lit tardigrade traveling freely in space with lightning flashes. No spacesuit of any kind. So here's the tardigrade. Here is the tardigrade in Star Wars, which you've got the difference between 16-bit graphics and a fully 3D rendered massive budget object here. But they're both styling off of the tardigrade actual animal. So is it infringement to use a tardigrade in both works? Probably not. However, to use them in the same way, that's where the infringement comes in. Because, like, if you just have a leopard in your work and the other guy has a leopard, there's nothing there, obviously. You didn't create leopards. But if you've got a magical psychic leopard that can pants people as it runs by at high speed or something, then the infringing work has the same thing. That's where you start to get interesting stuff. Carter, botanist, blue crew member uniform. Here's Carter's uniform. Here's this uniform. They're both blue. Actually, I don't see the similarities too much here. I think this is a bad exhibit, personally. This is a departure from the Star Trek uniforms, right? Look, it's got a collar. It's got these little, I don't know if these are like rank stripes or something, but they're these shoulder stripes. The cut is different. It looks more like a jacket rather than like a unitard, like the other Star Trek outfits. It looks a little different, for sure. Does it look like this? This one, not to me. Not to me. Star Trek. Did I say Star Wars? I apologize. Star Trek. Dr. Chantal, medical white gray uniform. Here's Dr. Chantal's uniform. Again, this uniform, while being a departure, this one looks a little more like this one, but you've got vertical striping as opposed to horizontal striping. The fact that they're white and gray versus white and gray here doesn't really make much sense. But if they're both medical uniforms, I guess there's a similarity. To me, the uniform similarities, you throw them in, but they're not very strong. Here's Yolanda, black female with short hair. Here's this black female with short hair. Again, I think he should tie the importance of the characters together if he can. Maybe he can't. Maybe he can't. But if this character is similarly important or plays a similar role to Yolanda from the game, that's going to matter, in my opinion, more than whether or not they just have black women with short hair in the show. Shinto Ketchup says, an 8-legged creature that travels through space is pretty specific. Yes, it is. It is. But tardigrades are real microscopic organisms. They're real things. So while it is specific to have an 8-legged creature that travels through space, it is not specific to have a tardigrade, because, you know, they weren't created by this guy. They were created by God or science or whatever, evolution. Baal of Babylon says, are you available for assistance in writing a warrant to search electronics from items seized from property based on a signed search seizure warrant? If yes, how much would it be for time? If no, keep the donation. You deserve it. Baal, my buddy, thank you very much for the super chat. That is something you would need to discuss with me in an email. Let me go ahead and send it to you. Rekieta Law. This is my public work email. Rekieta.org. Feel free to email me your issue and I can look at it then. I really do appreciate the donation. With the information you've given me, it's just not something I can answer over the stream. But feel free to email me and we can talk about it. If I'm not the right guy, I can maybe help you get to the right guy or help you with your issue in some other way. So, all right, buddy, thank you very much for that. I appreciate it. I'm happy to help out. Just please go ahead and email me on that one. If Tardigrade was created by a higher power, it had to be Satan. Okay. Next. Oh, that's the last of the similarities provided. I think personally, those are the interesting art similarities and visual similarities. I think they have laid out some story similarities, but it'd be good if they could add a little fluff to this, to talk about the characterization or other similarities that they could focus on. Personally, I think that. Personally. Next, what do we got? That's the similarities document. Let's go with the... All right. I have a couple other, like I have the articles that they listed in the things, and we might get to those in a minute. Sour Grape Soda says, I'm going to send so much dolphin porn to that email. Please, I only accept whale porn, a la John McAfee. So if you're going to do that, please make sure it's appropriately whale porn. Dolphins are disgusting, degenerate creatures. Whales are truly magnificent. Also, we know what Jonah was doing inside the whale. Apparently, Medicare has helped us with that. Let's see. Hold on. I got to get my windows organized here again. Someday I'll fix this out. Okay, so this is a letter sent on December 3rd. There is a lot of procedural practice that has happened in here in this lawsuit. As I mentioned, the current procedural footing is that the scheduling conference has occurred and a scheduling order has been sent laying out that the third amended complaint must be filed if there is going to be one by January 15th. That's in 4 days on Tuesday. And then a motion to dismiss would be February 25th. A motion or the opposition to the motion to dismiss would be not February 25th, February 12th. The opposition to the motion to dismiss would be on March 5th. And then the response would be on March 12th. So that's where we are right now. Again, that kind of sets the schedule through April, which is when the order would be on any motion to dismiss. And there's definitely going to be a motion to dismiss in this case. Let's see. So here is a letter, though, from Wu Quang, partner at Loeb & Loeb, LLP. This is a letter from CBS Broadcasting's attorneys to the Honorable Naomi Rice Buchwald and Daniel Patrick Moynihan at the United States Courthouse. Dear Judge Buchwald, we represent defendants CBS Broadcasting Incorporated, CBS Interactive Inc., and CBS Corporation collectively, and Netflix. So it's the same attorney for all of the defendants in the above referenced action. In accordance with Rule 2B of Your Honor's individual practices, we write to request a pre-motion conference in advance of defendant's anticipated motion, pursuant to Federal Rule Civil Procedure 12B6. Okay, so this judge has personal practices that are requesting a pre-motion conference prior to setting up the motion to dismiss, probably so they can schedule it out. Okay, this letter makes immediately more sense when I read it. To dismiss the second amended complaint of plaintiff Anas Osama Ibrahim Abdin. Background. So here they're going to lay out their kind of factual background. Tardigrades are near microscopic animals discovered in the 18th century that are known for their ability to survive in Earth's most inhospitable environments and, indeed, to survive unprotected in space. Citation. C. K. Ingmar Janssen et al. Tardigrades survive exposure to space in low Earth orbit. Available here. So if you guys want to read that, it's right there. Here we show that tardigrades are also able to survive space vacuum without loss in survival, and that some specimens even recovered after combined exposure to space vacuum and solar radiation. These results add the first animal to the exclusive and short list of organisms that have survived such exposure. By this action, plaintiff asserts copyright infringement and related state law claims based on the fundamental premise that he owns an exclusive monopoly on the right to create space-based fictional works that depict enlarged tardigrades in space. That's not true. That's not at all what he's asserting, and I think that sentence is a little disingenuous. Plaintiff argues that he is the creator of an unreleased video game called Tardigrades, which he posted in the form of articles, artwork, and videos on a few websites, including his own, between 2014 to 2017. The substance of these materials is compiled in a treatment annexed as Exhibit B to the complaint, which describes a single-player, user-driven video game set on a space station orbiting Jupiter in the year 20,000 BC, when Earth's civilizations are about to discover intergalactic travel. The treatment anticipates that the video game will include a plot twist and several themes, slavery, secrecy, and espionage, but provides no details concerning the plot or themes. Significance of tardigrades is also left unexplained, except in a few pages of comic book style artwork showing a boy apparently being bitten by a tardigrade and noting in comic book bubbles that tardigrades can survive in extreme conditions, including the vacuum of open space and solar radiation. Again, their characterization of this is defensive, and it's well done defensively. However, I think it is a little disingenuous. Maybe he's getting bit. I don't know. Maybe he's getting boned from behind, right? Maybe it's Who's that guy? This is a Penn State guy. Joe Paterno? Was it Joe Paterno? He wasn't the guy who did it, though. He just knew about it. I can't remember the guy who was actually assaulting all the children. Depends on the child, though. Plaintiff's treatment also provides short vignettes briefly describing 7 of the game's characters. Defendants own the right to the CBS television series Star Trek Discovery, the newest addition to the Star Trek franchise. Discovery tells various interweaving storylines through the 15 episodes of its first season, which initially aired between September 2017 and February 2018. The series begins with the commencement of a war with the Klingons, promoted by prompted by the actions of one of Discovery's main characters, Michael Burnham, a Vulcan-raised human played by an African-American female. Wait. Why is her name Michael? The Klingon War is the underlying thread throughout most of the season. Why? The Klingons must be... Wait, no. Vulcan-raised human played by an African-American female. Okay, never mind. Klingon War is the underlying thread throughout most of the season. Later episodes also focus on the USS Discovery's attempts to escape a mirror universe in which they have become stranded. One of the many storylines enmeshed within these 2 primary story arcs involves a rescued creature named Ripper, of a species considered cousin to the Earth-based Tardigrades. They're cousins now. That makes it okay. Michael Obama. Aww. Jerry Sandusky. Jerry Tight End Sandusky. Thank you. Thank you, chat, for pointing out that it was Jerry Sandusky. So maybe the Tardigrades wasn't biting him. Maybe he was Sanduskying him. Right? Like that's happening. Whose DNA is necessary to the functioning of the USS Discovery's experimental mycelial spore drive network space travel technology. That's okay. Knowledge of Star Trek Discovery absolutely aside, because I have never watched and probably never will watch an episode. But creating a mycelial spore drive network, like in anticipation, did they anticipate rescuing a creature named Ripper, whose DNA they would rape and pillage to cause interstellar travel? Like, is that what happened? I don't get it. That seems very precognitive. Based on the common use of enlarged space-based tardigrades and an assortment of other random similarities, e.g. a gay male couple, plaintiff asserts 4 claims for copyright infringement, all based on the same alleged infringement, but seeking 4 separate remedies: permanent injunction, actual damages, statutory damages, and attorney's fees and costs. Each of these copyright claims also allege violations of the Berne Convention and the Visual Artistic Rights Act of 1990. Second Amendment complaint also asserts 2 state law claims for constructive trust and for an accounting. Berserker Pride says Discovery is stupid. Spore drives are more stupid. Grounds for dismissal. Yeah, 7 Screaming Dizbuster says that stuff wasn't in the old Star Treks I saw. And isn't that interesting? They just happened to come up with this at the same time. Well, they built the spore drive, then found out the tardigrade was a key to controlling it more effectively. Thank you, Duff Guy. Thank you. I have no idea any of this. It just all seems very coincidental at this point. Plaintiff's claims for copyright infringement failed to state a claim. Parties' works are not substantially similar as a matter of law. This action fundamentally fails and should be dismissed because there are no actionable similarities between plaintiff's treatment and Discovery. Copyright plaintiff must establish inter alia that substantial similarity exists between the defendant's work and the protectable elements of plaintiffs. Is that spelled right? It doesn't look right. Okay, it is able, not able. Protect able? Maybe it's an interchangeable spelling. That's amazing. Yeah, protect Ibble and protect Able are apparently interchangeable. So I've learned something new today. It didn't look right to me, but okay. Who might argue with the dictionary? Let's see. Protectable elements of plaintiffs. That's Peter F. Gaito Architecture LLC versus Simone Development Corp. Second Circuit law is clear that copyright claims should be dismissed at the pleading stage where either, quote, the similarity between two works concerns only non-copyrightable elements of the plaintiff's work, or because no reasonable jury properly instructed could find that the two works are substantially similar. Quote, it is a principle fundamental to copyright law that a copyright does not protect an idea, only an author's original expression of that idea. Similarly, copyright law does not protect facts, including scientific fact, because they do not owe their origin to an act of authorship. Okay, CBS attorney. Tardigrades may be able to survive in space briefly, according to one study. What they can't do is rape a naked blonde man and make him travel through space faster than light along with a spaceship. Those are not scientific facts that are not subject to copyright. Just so we're clear. The Sandusky Drive is not part of the scientific study about tardigrades. Good Lord. That's kind of embarrassing. Okay. It does not protect facts, including scientific facts, because they do not owe their origin to an act of authorship. Each defendant had the right, so this is the citation. Each defendant had the right to avail himself of the facts contained in Holding's book and to use such information, whether correct or incorrect, in his own literary work. Also unprotectable are sans affaires, which the Second Court has described as sequences of events which necessarily follow from a common theme, as well as incidents, characters, or settings which are as a practical matter indispensable or at least standard in the treatment of a given topic. So what he's going to say here is gay people have gayness. That's from Nobile versus Wyatt's, affirming Rule 12b6 dismissal of copyright claim for lack of substantial similarity. After extracting such unprotectable elements, courts ask whether the works as a whole are substantially similar. Based on these black letter principles, plaintiffs' copyright claims fail at the threshold because the basic plot premise of an enlarged tardigrade in space is not protectable. Why did you switch to protect Able? Be consistent! Protect Ibble or protect Able. That tardigrades are able to survive unprotected in space is a scientific fact that is not original to, much less exclusively owned by plaintiff, nor can plaintiff claim ownership of the basic idea of using tardigrades in a fictional science-based story any more than an author could claim copyright protection over the idea of placing dinosaurs on a fictional island zoo. The question is, could an author claim copyright over a giant ape? Could a author claim copyright over a giant ape? A giant ape that has specific characteristics. Now they picked Jurassic Park because you can't copyright dinosaurs on a fictional island zoo. But can you copyright dinosaurs that were cloned using DNA extracted from amber from a mosquito and then replaced with frog DNA that switch genders, that do the full Jenner? Do the full Jenner to reproduce because life finds a way. Okay, indeed, even before plaintiff alleges to have posted his works on the internet in 2014, the idea of using tardigrades in the Star Trek franchise was posited by the well-known publication Scientific American. See Kyle Hill, How Tardigrades Saved the Enterprise, Scientific American 2013, opining that Captain Kirk should have used tardigrades to save USS Enterprise in 2013 film Star Trek Into Darkness. There you go. There you go. Let's see. Next. So that's their defense of Jurassic Park, which is weird. Why did they do Jurassic? Why did they footnote that for Jurassic Park? They should have footnoted a case saying that Michael Crichton couldn't copyright dinosaurs on a fictional island zoo. C. Williams, there it is. Placing dinosaurs on a prehistoric island far from the mainland amounts to no more than a scene affair in a dinosaur adventure story. Yeah, sure. What was that? When was this Williams case? Williams versus Crichton, 1996. There we go. The SAC, Second Amended Complaint, places great emphasis on the fact that the tardigrades appearing in the parties' respective works are size larger than a human being, but this type of adaptation of the actual species naturally flowing from the very idea of a tardigrade-based character is not protectable either. The humanizing of a domino, this is Ali versus Domino's Pizza. The humanizing of a domino is an idea not subject to copyright protection. Green versus Procter and Gamble, the idea of characterizing oral bacteria as humanoid cavity makers is hardly protectable. And notwithstanding plaintiff's allegation to the contrary, whether or not tardigrades had previously been used in a Star Trek work is irrelevant, as there is, of course, no requirement of prior use or commonness to use basic plot concepts. But again, star traversing tardigrades are not a basic plot concept, I would argue. Oh, Gojirify says Spore Drive never existed in Star Trek before. There you go. Let's see. Where are we? So this is citing Dean versus Cameron. Suspending a landmass is a predictable, if not common, way to make a vista more sweeping, breathtaking, and fantastical, and is plainly subject to both principle that the ideas are not protected in the doctrine of scenes affaire. Here, after extracting the unprotectable use of tardigrades, all that remains are random similarities scattered throughout the works, which cannot support a finding of substantial similarity because it fails to address the underlying issue, whether a lay observer would consider the works as a whole substantially similar to one another. The interesting thing is I think a lay observer might, but I don't know. Are any of you guys... Okay, any of you guys who have watched Star Trek Discovery, we'll ask the chat. I know there aren't too many people on, let's see, on Streamy, but I can actually make a pool. STD versus tardigrades. Poll answer. STD copies tardigrades. And next answer is these things are not the same. Okay, so Streamy, if you could help me out, I'm gonna put just a like 3-minute timer on the poll. If you could help me and vote on which one of these? To you guys who have seen, and of course the other chats can participate, but not on Streamy. If you have seen Star Trek Discovery and you've looked at the tardigrades information, do you think, as lay observers, that Star Trek Discovery took the idea from tardigrades? I think that's an interesting question. In the chat, 1, if you think Star Trek Discovery copies tardigrades. 2, if you don't see any similarities. Again, I have not watched the show. I'm not a lay observer because I have not observed the 2 works. All I've got are the lawsuits. So if you guys can help me out there, I would really appreciate it. Go ahead whenever you're ready, and I'll say whatever results we get. They obviously won't be disclosed. Or they obviously won't be conclusive. They'll be disclosed, not conclusive. Okay, so all that remains are random similarities scattered throughout the work, which cannot support a finding of substantial similarity because it fails to address the underlying issue, whether a lay observer would consider the works as a whole substantially similar to one another. That's citing Williams. Indeed, most of the claimed similarities are generic and stock elements that are used in countless works, including, for instance, a gay relationship, Holy cats, I'm getting a lot of ones. A lot of ones. A gay relationship, uniforms which delineate rank, and the use of the term emitter to describe a light-emitting device. Nor does plaintiff own the stock character elements he claims to have been infringed, such as a blonde white male who is a scientist, a darker complexion homosexual male, and a female of African-American descent with messy curly hair. C.E.G. Hogan versus DC Comics. A stock character or basic character type is not entitled to copyright protection. No infringement where two characters had same name and were both half vampire and half human of similar age and shared other characteristics such as thin to medium builds, pale skin, dark messy hair, and a slovenly appearance. Now, again, I think they're mischaracterizing the copyrighted issue. And that's why I think they need to bolster their claims with more plot elements rather than just appearance. Next, plaintiff fails to identify any allegedly infringed work other than the treatment. Though relying on the registered treatment for his claims, plaintiff confusingly defines the allegedly infringed original work to encompass other materials published on various websites, including Adventure Game Studio forums, an astronaut blog, YouTube stream games, and Reddit. The Second Amendment amended complaint does not provide hyperlinks to any content plaintiff claims to have posted on these sites, not attach any materials from these sites, and it provides no other means by which defendants could determine that what, if any, additional materials posted on these sites have allegedly been infringed. To the extent plaintiff purports to rely on these unidentified materials, Second Amendment complaints copyright claims do not satisfy well-settled pleading requirements and should be dismissed. Rule 8 requires copyright plaintiff to allege inter alia which specific original works are the subject of the copyright claim. And then plaintiff has not provided a list of the works potentially at issue in this case and thus fails to meet the first Kelly requirement. Now, I don't think that's true. I think they should bolster, again, if they're going to do a third amended complaint, bolster it with additional facts from the show, additional story elements rather than just visual elements. The visual elements are powerful, of course. Story elements would be better. But I do think that the tardigrades being space traveling, disgusting beasts probably does actually satisfy the pleading requirements. Just that, I think, is enough. So the results are in. On the Stream Me poll, we've got 13 saying STD copies tardigrades and 6 saying these things are not the same. So there you go. Would a lay observer do that? The poll says, on average, yes. The unofficial poll, I see all of them stating that it copies. All of the responses I got on YouTube do state that it copies the original work. Plaintiff does not and cannot adequately allege access. Plaintiff's copyright claims fail for the additional reason that the second amended complaint's bare and speculative allegations do not plausibly establish that any defendants had access to and thus actually copied plaintiff's works. To establish access, the second amended complaint must plausibly allege either 1, a particular chain of events or a link from his work to the creators of the allegedly infringing work, or 2, that plaintiff's work was widely disseminated. Here, the complaint does not allege a particular chain of events from plaintiff's work to anyone involved in the creation of Discovery, and instead alleges in conclusory fashion the plaintiff's works were widely distributed when plaintiff posted his works on certain websites. But, quote, the mere fact that a plaintiff's work was posted on the internet prior to the creation of defendant's work is insufficient by itself to demonstrate wide dissemination. That's O'Keefe versus Ogilvy and Mather Worldwide. Quote, plaintiff's sole allegation with regard to access is that the work was uploaded to YouTube in 2009. However, this does not imply it was disseminated widely, and the First Amendment complaint provides no facts to support such an inference. So this is my criticism. They did say how many views and how many visitors the blog posts, YouTube, and Reddit got collectively. YouTube getting 12.8 billion views per month. But that doesn't say how much these particular videos received. Now, it is not hard, in my opinion, logically, to argue that distributing something on a popular science fiction forum means that science fiction writers are prone to maybe see it. Right? So I think they should just establish, if they can, the number of views or responses to the thread involved, the number of views of any videos, the number of upvotes and downvotes on the Reddit, stuff like that. Stuff like that. Rather, a work is, widely disseminated when it has had considerable commercial success or is readily available on the market. Plaintiff's allegations that he posted preliminary materials for his unreleased video game to a few websites if true, establishes neither. I actually don't think that's true. I think they just need more data. Plaintiff is barred from seeking statutory damages or attorney's fees. Plaintiff's claims for statutory damages and attorney's fees pursuant to sections 504C and 505 of the Copyright Act independently fail because all of the allegedly infringing episodes of Discovery aired before the effective date of the registration of the treatment. Copyright Act expressly provides that no award of statutory damages or of attorney's fees as provided by sections 504 and 505 shall be made for any infringement of copyright commenced after first publication of the work and before the effective date of its registration, unless such registration is made within 3 months after the first publication of the work. Here, the effective registration date of the trademark is June 28th, more than 3 months after the stated first publication of plaintiff's works in July 2017, and after Discovery first aired in September 2017. I mentioned this before, that he might be time barred by collecting those statutory damages. Even where the alleged infringement begins before registration and continues after registration, statutory damages and attorney's fees are still unavailable. That's quoting Solid Oak Sketches. Accordingly, any claims for statutory damages and attorney's fees are barred. That is a big, big problem. I'm not sure how they're going to overcome that. They might have to incorporate the 2015 copyright, depending on what's in there. Plaintiff has no claim, and it depends on when that 2015 copyright was filed. Plaintiff has no claim under the Berne Convention or VARA. Plaintiff's claims under the Berne Convention and VARA also each fail. First, the law is clear that there is no private right of action under the Berne Convention, a treaty that is not self-executing. Plaintiff's claim under the Berne Convention is not cognizable under U.S. law. That's citing a different case. Every judge in this district who has considered whether the Berne Convention is self-executing has concluded that it is not. Berne Convention does not confer federal jurisdiction. Second, VARA also does not apply to plaintiff's works. VARA affords protections only to authors of works of visual art, a narrow class of art defined to include paintings, drawings, prints, sculptures, or photographs produced for exhibition purposes existing in a single copy or limited edition of 200 copies or fewer. Plaintiff's treatment falls within none of these categories. Plaintiff's claims regarding Netflix. Now, interestingly, they mention the Berne and VARA claims, but they don't really mention them heavily. It's mostly under the copyright statutes. Let's see. Plaintiff's claims with respect to Netflix's international distribution of Discovery fail for the additional and independent reason that the U.S. Copyright Act does not apply extraterritorially, dismissing copyright claim arising from allegedly infringing conduct in the UK and Europe. The only domestic act attributed to Netflix is having entered into a social contract into the United States with the CBS defendants. But the mere act of licensing allegedly infringing works for foreign use does not constitute copyright infringement. See Fundamental 2 Ltd versus Gemi Industries Corporation. Mere authorization and approval in the United States of copyright infringements taking place outside of the United States is not a copyright violation, does not create jurisdiction over those extraterritorial acts. Now, I don't know if that actually applies because it's not mere authorization and approval in the United States of copyright infringements taking place outside the United States. It's a US-based company licensing an infringing work and using it outside of the United States. That's a little different there. It's a little different. Plaintiff's state law claims for constructive trust and accounting are preempted. Plaintiff's state law claims are barred, among other reasons, by the fact that each of these claims are preempted by the Copyright Act. But you just said the Copyright Act doesn't apply. So the Copyright Act doesn't apply, then they can't be preempted. Defendants respectfully request a pre-motion conference to address their anticipated motion to dismiss based on the foregoing. We thank the court for its attention to this matter. Respectfully submitted, Wu Kwang partner, plaintiff's counsel. There you go. Now, Annis has, his lawyers have responded. And I want to make sure and cover that. This is from John Johnson and Associates, New York, New York. All right. Honorable Judge Buchenwald. Let's see here. Whoops. So the Honorable Judge Buchenwald. Pursuant Your Honor's rules. Why are you missing the article? 2, Your Honor's rules. Plaintiff hereby responds to defendant's request for a pre-motion conference. The defendants have misrepresented the factual scenario. In this matter, why this guy? I don't know if he's using voice to text or whatever, but if I was a judge, I would be really annoyed reading this. I'm annoyed reading this now, and I fix these minor mistakes to the fact misrepresented the factual scenario in this matter, and therefore attempt to conform the misrepresentation to the law. Accordingly, the record must be set straight, following in order of the movement's request. Factual background. A. While tardigrades are found in nature, the plaintiff, via his imagination and ingenuity, created a widely distributed treatment, musical LLC. Plaintiff does not assert that he has a right to a monopoly on creation generally. However, the fact of the matter is that plaintiff did create such a character prior to the defendants. Plaintiff's second amended complaint clearly demonstrates that the Tardigrades treatment was in fact released on gaming websites throughout the world. Hundreds of thousands of interested fans viewed the treatment there, and that is not clear in the second amended complaint. That is not clear at all. They should get that data. And point out how many people have viewed the treatment. The defendant's use of words such as unreleased, a few websites, is wholly misleading. Further statements such as the treatment anticipates would lead the court to believe that plaintiff's assertions are insignificant and that the game itself was only viewed by a few people, all of which are wholly untrue. Defendants, dude, no apostrophe in defendants. Why? These guys have to be drafting these documents with like Dragon Naturally Speaking or something. Learn to type. Get rid of those apostrophes. Turn off autocorrect, whatever it takes. Defendants dismiss plaintiff's VARA claims while on the other hand admitting that plaintiff established comic book style artwork. Plaintiff's comic book style artwork shows substantial, if not striking, similarity to the plaintiff's work. No, to the defendant's work. In fact, in viewing the second amended complaint attachments, it's as if the plaintiff's original work was used as a storyboard for the development of Star Trek Discovery. Defendants then further admit, why apostrophes are pissing me off, the Discovery tardigrade is necessary to the functioning of the Discovery spaceship's instantaneous star travel, and there are related similarities. Defendants omit the fact that this giant blue tardigrade was captured by the Discovery crew, and the tardigrade's power of instantaneous space travel was the central theme of the show. The central theme was later used derivatively via tardigrade DNA. Central theme is in no way common. I agree with that. Second amended complaint clearly establishes claims for which relief can be found. Plaintiff's second amended complaint clearly state claims for which relief can be granted. Parties' works are substantially and or strikingly similar. Defendants' inaccurate use of the facts were inserted into legal precedents in an attempt to distort the issues at hand. That's the defense's job. Once again, plaintiffs make unsupported allegations of no similarities and that Tardigrades the game was simply an idea. Notwithstanding defendants' admissions of similarity, plaintiff has established facts sufficient to warrant trial. As Judge Sweet in Arma versus Seasons states, in considering a motion to dismiss pursuant to Rule 12b-6, court construes the complaint liberally, accepting all factual allegations in the complaint as true and drawing all reasonable inferences in the plaintiff's favor. I agree. This should survive a motion to dismiss. But it should be cleaned up. Make it stronger. You have the opportunity to do so. You have 4 days. Make it better. Chambers versus Time Warner, citing Gregory versus Daly. As stated in ARMA, 4 requirements must be met to withstand 12b6. Briefly, A, what original works are claimed? B, ownership of copyright. C, registration. And D, by what acts during what time the infringement occurred. Plaintiff has met that burden with specificity. 2. Turning to the question of similarity. The standard test for substantial similarity between two items is whether an ordinary observer, unless he set out to detect the disparities, would be disposed to overlook them and regard the aesthetic appeal as the same. That's Gaito architecture. This test, often referred to as the ordinary observer test, asks whether an average lay observer would recognize the alleged copy having been appropriated from the copyrighted work. The proof that a lay observer would not overlook the similarities can be found in the many YouTube and gamer websites' discussions of the matter, as the second amended complaint demonstrates. Just some ordinary observers. AdventureGameStudio.co.uk. Gurok said, oh, speaking of the Spore Drive, I couldn't help but think of Anis Abdin when watching it. The Discovery Spore Drive is Tardigrades powered. That's Steam-based game Tardigrades. Then the Omega Sector as is Star Trek Discovery guilty of plagiarizing the Tardigrade? YouTube video, Star Trek Discovery, was the Tardigrade idea stolen? Sing a song of Tardigrade, Star Trek Discovery, and plagiarism. A Tale of Two Tardigrades, Star Trek Discovery, a plagie le point and click. Le point and click. That's from Rock, Paper, Shotgun. Okay, sorry. Tardigrade character and its abilities are well set forth. Nimmer suggests that characters are depicted visually are more easily protected than those that are mere descriptions in novels and short stories. The Second Circuit has long held that characters are protectable. Defendant's motion to dismiss claim denied. Oh, that's quoting Lone Wolf versus Quaid Association. In Debec de Livier versus Anastasia Musical LLC, the court, in addressing substantial similarity, states the court must be guided principally by comparing the two works' total concept and feel. In the instant matter, any such comparison clearly establishes infringement. Defendant incorrectly cites in support of its motion Green versus Procter & Gamble, which compared human actors versus cartoon characters. In a further attempt to misdirect the court, defendants cite a Scientific American blog post which discusses tardigrades as tiny microscopic organisms which could be used to withstand radiation. The article does not in any way state that tardigrades could be used for instantaneous space travel or are the size of human beings. Scientific American blog post only references them as small organisms used for the absorption of radiation. Defendant's misuse of Ollie versus Domino's Pizza is again misdirecting the court. Also indicated that the defendants are pedophiles because they're clearly using a code, Ollie versus Domino Pizza, which is jumping over a number of children to molest them. We know that's true. Hillary Clinton said so. Is again misdirecting the court. The court in Ollie held that the two figures were wholly different. In the instant matter, not only are the characters substantially similar, the total concept and feel is substantially similar. Ollie stood for the fact that the only similarity arose from the Domino's trademark, otherwise the characters were dissimilar. Although the Dominoid and Donnie Domino are similar in that their bodies consist of a domino with one dot at the top square and two dots at the bottom square, the court finds that this similarity is attributable to the fact that both works use Domino's trademark domino as the body. However, the humanizing of a domino is an idea not subject to copyright protection. The case does not stand for the proposition asserted in defendant's pre-motion request. Assuming defendant's argument had validity, a work may be copyrightable if, even though it is entirely a compilation of unprotectable elements in such works, the original inheres in the way the author coordinated, selected, and arranged the elements of her work. That's important. That's very important. Yes, of course, it's fine to have a brown gay man with a beard and a goatee be in a relationship with a white blonde gay man, right? Like, that is not copyrightable. However, in the totality of the work, to have a relationship that looks shockingly similar to the relationship described in the work where there are other infringing elements, specifically the tardigrades, instantaneous space travel. We're talking about really, really questionable things. And when you take them as a whole, they start to look like the same thing. And that's the big, say tardigrade 3 times fast. Tardigrade, tardigrade, tardigrade. But that seems to be, that's the whole thing. I actually will assert that the tardigrade itself is a gross enough infringement of copyright to bring a claim or a cause of action, specifically to any episode involving the tardigrade, and then probably any episode where they derivatively use a tardigrade. So, but that's my opinion. The so-called random similarities. Defendants dismiss the additional similarities between the works as random. This categorization flies in the face of the test for substantial similarity, as stated in De Bec de Livière. The court must address the total concept and feel. To simply dismiss the numerous similarities as random is wholly without merit. However, defendants admit similarity exists in the non-tardigrade elements. Again, plaintiff does not claim a monopoly on the so-called stock elements. Plaintiff does allege that those elements, as copied by Star Trek Discovery, directly infringe the original work. Oh, excuse me. Reference to the infringed work was, as well as a comparison to the television show, was attached to the second amended complaint. Second amended complaint meets the pleading requirements. It does, but I think it could use some bolstering, and you have the opportunity to do so. Take it. Take it, take it, take it. 18 naked tardigrades at Ram Ranch. Oh, the tardigrade Ram Ranch is real. Defendants allege that they cannot know exactly what work has been infringed and mistakenly confuse the citations in the second amended complaint. Defendants state they cannot determine what additional material posted on the sites have been infringed. Second amended complaint provides the URLs of websites which purport the allegation therein. In fact, most of the references point to the average ordinary observer's comparison of the two works. Plaintiff's second amended complaint comports with the Plunkett in that the treatment provides defendants with a list of the allegedly infringing items. If the defendants believe the list is not adequate, Plunkett stands for the proposition that amendment may be had to cure any such deficiencies. Additionally, any such issue can be cured during discovery. Copyright Act does not apply extraterritorially. Defendants allege that the U.S. Copyright Act does not apply extraterritorially. We do not argue with this application law. The defendant neglects or misunderstands the Predicate Act doctrine in Update Art Inc. versus Modin Publishing. It is well established that copyright laws generally do not have extraterritorial application. There is an exception when the type of infringement permits further reproduction abroad. That's Peter Star Productions Company versus Twin Continental Films Incorporated. Copyright infringement pursuant to VARA provides for statutory damages. 17 U.S.C. 106A and 504 clearly provides for statutory damages and or attorney's fees, as the second amended complaint asserts. See generally and see Cohen versus GM Realty. So there you go. That is the proposition. These two letters taken together led to the conference setting out the scheduling that I mentioned at the beginning of the stream. And let me go ahead and just refresh anyone's memories if they weren't here at the beginning of the stream. For the reasons stated at the conference held on January 8th, hereby ordered that plaintiff shall file his third amended complaint, if he wants, by January 15th. Further ordered that defendants shall file their motion to dismiss, if any, by February 12th, not to exceed 25 pages. Plaintiff shall file his opposition to defendant's motion to dismiss by March 5th, not to exceed 25 pages, and defendants shall, defendants shall file their reply, if any, by March 12th, not to exceed 10 pages. Parties shall comply with the court's individual rules, including exhibit limits and courtesy copies. So that is where we are right now. So we have approximately 4 months before a judge rules on this issue, if they follow the timelines But there will be some more documents dropping. So that's it. I have a bunch of the articles that they cited. Like, I'll pull them up, but I'm not going to go through them all. Like, here's by Darren Orff. Here's an article called Star Trek Discovery is a Tale of Two Torchbearers, about that spore drive. Let's see. Lieutenant Paul Stamets laid out the theoretical framework for Discovery's out there mode of transportation. After some biology is physics, bong rip kind of talk, explains that microscopic organisms making up the fabric of space could somehow be manipulated to travel the cosmos. Manipulated being the key word. You might remember that Discovery last week introduced a horror monster in the shadows, one that had run rampant on the USS Glenn, killing Klingons and the crew there and chased the Discovery away team that came aboard. Captain Lorca assigns Birmingham to learn more about the beast. He's interested in how it repels phasers and Klingon botleths and believes it could be studied and weaponized. Burnham delves into the creature's biology and begins to learn much, much more. The former first officer figures out she's dealing with an overgrown tardigrade. In real life, tardigrades are those tiny water bearers, blah, blah, blah. Let's see. Let's see where they bring it out. Stray thoughts. Where is it? Whoa. So this is interesting. This article that they cited. Again, I haven't read this stuff. Let's see. I'm trying to find where this article cites the tardigrades. I'm not finding any reference in this one. Now, I don't know why they brought it up, but this one sure doesn't reference the Anis Abdin piece. So this is a weird one to include. But I don't remember the context of the citation. Let's look at the next one. Fistful of Vulcan. Oh, this is another one by Darren Orff. The same thing. Same guy, I mean, same publication. Let's see if he mentions it. Our Vulcan mind. My captain. I'm not really finding. Let's see. Yeah, I'm not finding anything about Anis Abdin stuff in here. Maybe it's in the next article. Nope. These are weird to include, in my opinion, because they don't seem to indicate that that there's any infringement on this one. Let me look at the other articles. This one is from Advocate. Jaw-dropping mid-season premiere of Star Trek Discovery, which left many fans in uproar over beloved character's death. Well, this is about gays. Gays getting killed. Apparently, you can kill gays on TV. But maybe not. Bury your gays. That's what they say. A trope in which gay characters are seen as expendable in film and television productions. Who knows? Where's the... There's gotta be. Rock, paper, shotgun? What do they say? Okay. Rock, paper, shotgun has some love here. 1 second, though. Keck7 Go says, "Morning, Nick. What have I missed? Any highlights akin to your time as a gay man?" No. So here's the Star Trek Discovery. This is a rock, paper, shotgun. So this is a video game publication talking about Star Trek Discovery and the infringement. Tardigrade by Annis Abdin is about an ancient race of Earthlings. This was November 8th, 2017. So yeah, this is them noting it. I'm not going to read through all this. Okay, so this is interesting. Abdin notes many more similarities between the show and his game, which to an outsider are perhaps less suspicious than to the developer, who suddenly had the rug pulled out from under him. The black female lead in both projects and a gay couple both have a character with blonde features that border on albino. For Abdin, this created the impression that Discovery was just taking his ideas one by one. I suspect otherwise. Tardigrade is unusual, but beyond that, the other similarities Abdin mentions could be found in any number of new television series. It seems astoundingly unlikely that Star Trek's producers would have cast a show to match the pixel art of an unreleased game, but it's easy for me to feel detached about this, not so for Abdin. I don't know. I don't know that it's as unlikely as they think, as he thinks, but I think that that line in the article is kind of devastating. That line in the article is not great. Yeah, sorry for the dead air. I was trying to read through these things without like actually reading every single word because I'd rather wrap up. But I wanted to be thorough in the documents that are out there. I'm not so sure that the evidence presented are there. Screen Rant. Let's see. Who knows? Let me see. Whoa! Here we go. I don't know if it's actually searching for words. Who knows if they actually made a real PDF. I'm not going to go through all this. The long and short is I'm not sure these... I'm not sure that these exhibits are as helpful as they make them out to be. I do think... Here's my... Let's get back to this. Let's get back to this lawsuit. What bothers me about this, what I think needs to happen, I think they do need a third amended complaint. I think they need to solidify the amount of viewers their individual posts and videos got. Just tally them all up in a rough total and throw it out there. Provide some evidence. Now, they're saying hundreds of thousands of people saw these posts. Okay, that's good. Put it up there. Put it up there. That'll show the judge how many people are actually looking at this. Not just citing that, well, YouTube has 12.8 billion viewers per month, because that's not how many people are watching the Tardigrades, the Tardigrades releases, right? Like that's not the thing. Sorry to move this. So I think they do need to clarify that. I think they need to lay out plot elements, not just visual depictions. I think any characterization similarities or plot similarities that could go along with the characters would be better. And then the main thing is focusing heavily on the use of the tardigrade itself as powering the ship and being the driving force in the show, literally and figuratively. That needs to be Ben Cheevers says the references you couldn't find in the other articles are in the comment section. I bet lay people giving their opinions. Also, RPS are trash shills and would do anything for network. Rock, paper, shotgun. Very, very possible. Very possible. So I think they need to focus on those things in a third amended complaint, and they really should. They've gotten permission to do a third amended complaint from the judge. Do it. Do it. Clean up the stupid typographical punctuation errors that are in the second amended complaint. This is your amended complaint. There's far less excuse in an amended complaint. You're not, it's not your first work. You're revising it. Should be a second set of eyes on it. If you want someone to edit it, just call me. Just email me. I don't care. I will tell you where you're missing an article or where you're missing a quote or where you've got an apostrophe that doesn't belong. Weird errors to have in your amended complaints. But yeah, get the third amended complaint. I would say clean it up. Focus on the tardigrades. Maybe not focus so much on those articles unless you can point clearly to the people making the distinctions. Run a poll maybe. I don't know. That's probably not necessary at this point. But if you can find some better language in those articles, I think that would be helpful for you. To me, it looks like it's definitely infringing. I mean, it really does. But I've never watched the show. Seems to be a lot of support on here as well from people who have watched the show. So there you go, guys. That is the Tardigrades lawsuit as it stands right now. I will follow along. I'm not going to cover every document release unless there's some sort of bombshell in it, but I would like to. I'll probably revisit it when the judge issues an order on the motion to dismiss, which should be sometime early April. So yeah, if you guys have any questions. If you sent last night Dev an email, told them he should have told them to get stuff. Okay. Don't ever be willing to just wrap it up. All right. Well, guys, that's it. I think maybe they should bring in the statements from their initial phone call if they can further cement those statements. It's dodgy because the other party's going to say that those statements were made in consideration of a settlement. But quick thoughts on the shutdown? You talking about the government shutdown? Who knew we were in a government shutdown? Can we please get a real government shutdown? Like actually shut it down. That would be great. If we could actually shut down the government instead of just whining about the entire government working just fine, that would be wonderful. Shut it down. I don't care if the shutdown lasts until I die. It's stupid. Our government is way too big, way too bloated, and can stay shut down forever for all anyone cares. Courts work, the cops work, everybody still works. The only people who don't... The fact that we have non-essential government employees should actually offend people. That the government is paying someone for a non-essential job at all should bother all of us. And they should all be fired. I'm sorry if you're one of those guys. Get employed in the private industry. The government doesn't need to do something non-essential. But that's me. I don't care about it. I hope Trump drags it out and hammers on the Democrats until they do what he wants. I don't even want a wall. I don't care about a wall. Not on my agenda. I don't not want a wall. I just don't. It's not important to me at all. But if the president wants a wall, Congress has authorized a wall/fence like 10 times. Do it. Do it. Hold out for it, Trump. You've got the negotiation upper hand. Veto them. They don't have a 2/3 majority in the House and Senate. They can't override it. Defund Congress for all I care. So that's it. Yeah, Nick, chill. Don't fire me for working in the Gov. Sorry, Landoname. If you're still working, you must be essential. So what are you worried about, buddy? All right, guys. Need a wall on the Canadian border is actually true. Yeah, 3-7 says, this is on Streamy. I heard from Anis on some stream that he was happy because they didn't have to get permission from opposing counsel to file a third amended complaint. So I think he's planning on it. Yeah, that was also in his blog post. So I do think that he is planning on it, and he should. They should do it, clarify it. They've got an idea of where their opponent's opposition is. Solidify your pleading. That's what I would say. How can Congress get defunded? I don't know. They always seem to just pass continuing resolutions that include congressional funding. Maybe Trump should just veto all of them. Who knows? Who knows? In the states where governors have line item vetoes, like in Minnesota, you can apparently just line item veto out Congress. That's the funniest thing that I've ever heard of. Are there any specific laws I'd change if I had the opportunity? Yeah, weed would be legal tomorrow. There you go. There you go, MK18. And a lot of other stuff. Pretty much anything from anything restricting speech would be changed. Campaign finance reform would be gone. Keck7Go says, I learned that in Finland it's easier to start and do business than in America. WTF. That's likely true. Starting a business in America costs a ridiculous amount of money and time and compliance with all sorts of stupid things. So, all right, guys. I think we're good for tonight. Thank you all for joining me. I always appreciate it. I'm not quite sure what we're doing tomorrow. I'll be on mobile, so I apologize. I won't have my good mic with me. I'll have the old mic with me. I hope the sound doesn't spike on us, but I can make no promises. I will announce the subject tomorrow when I have it. But I look forward to talking to you all. Have a wonderful night. And Anis, if you're still watching, if you've seen this, or Anis's lawyers, best of luck to you guys. I really do hope you do well in this case. He does seem to be competently represented. My criticisms of the grammar and stuff are very, very nitpicky. The substantive law looks fine. And I do think they've laid out a case that will survive dismissal. That's the important part, is surviving dismissal, because after dismissal, everything gets more expensive and time consuming, and maybe he can get a settlement out of the deal, or maybe he can go all the way with it, and we'll see how that turns out for him. I think there's a good case that they copied stuff. The copied imagery is very, very coincidental to not be real. So, all right, guys. Would you be smoking if it was legal? Maybe. I don't know if I'd be smoking or doing, but consuming it in some way. It's possible. But of course I can't do that now because I cannot commit a felony, right? I'm a whatchamacallit? Oh, I'm an officer of the court. An officer of the court. Landoname says, I'm worried handsome men like you will convince them. My job is essential, I would say, but my lord, we don't need you guys asking how we are so employed. Sorry, buddy. I can't stop, won't stop. Michael Campbell says, grab a drink on me when you watch Andy beat a cripple. Will do, buddy. Will do. Gladly. Many of you, some of you, a few of you, I don't know. I will be happy to see in Knoxville. If you are there, if you're going to Knoxville to watch internet autism on full display in the form of an MMA fight, please don't hesitate to come up and say hi. I'm happy to say hi to anybody. I'm just going to be there observing, smiling, and laughing with the rest of you, having a drink, and I'm always happy to chat. So please do come up and say hi, introduce yourself. you know, that would be great. Can't wait to see some of you guys there. Can't wait to enjoy a spectacle, and can't wait to ruin whatever bar we all go to. All right, guys. You guys have a good night. Peace.